stop sharing.
All right, perfect. And then we'll just go from there and there we go. Everyone looks beautiful. Okay, great. At this time, I'd like to call this meeting to order. This is Thursday, September 23rd, 2021. This is a meeting of the Rent Stabilization Commission for the City of West Hollywood. Vice Chair Copeland, would you lead us in the Pledge of Allegiance, please? Commissioner Topchian, I love that.
Certainly. I pledge allegiance
To
the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. Madam Secretary, may we please have a roll call?
Commissioner Ayers?
Here.
Commissioner Kirby's?
Here.
Commissioner Maggio?
Here.
Commissioner Montemayor?
Here.
Commissioner Topchian?
Here.
Vice Chair Copeland?
Here.
Chair Martz?
Present. Thank you very much. We have a quorum. Has everyone had a chance to go over the agenda for tonight's meeting? I see lots of yeses. Anyone would like to make a motion? Mr. Maggio.
I'll make a motion to approve the agenda for September the 23rd, 2021.
I'll second that.
Great. We have a motion. We have a second. Madam Secretary, may we have a roll call vote, please?
Commissioner Ayers?
Yes.
Commissioner Kirby's?
Yes.
Commissioner Maggio?
Aye.
Commissioner Montemayor?
Aye.
Commissioner Topchian?
Aye.
Vice Chair Copeland?
Aye.
Chair Martz?
Aye, the motion passes. Thank you very much. All right, we have the minutes from our last meeting. Has everyone had a chance to review those? Any corrections or comments?
Just one.
Okay, go ahead.
I believe on approval of the minutes, I believe Commissioner Montemayor was absent previously, so he abstained. Is that right? Yeah.
That's correct.
All right, and then I also have one. Let me make sure I'm not going crazy on number 4. I think it says Vice Chair Ayers. Does that say? Yeah, approval of the agenda, motion by Commissioner Montemayor. It should be Commissioner Ayers. Is that correct for everyone? All right. Anyone want to make a motion with those 2 amendments?
With this modification, I move to approve the minutes.
A second.
All right, we have a motion and a second. Madam Secretary, a roll call, please.
Commissioner Ayers?
Yes.
Commissioner Kirby's?
Aye.
Commissioner Maggio?
Aye.
Commissioner Montemayor?
Aye.
Commissioner Topchian?
Aye.
Vice Chair Copeland?
Aye.
Chair Martz?
Aye, the motion passes. Thank you very much. Moving right along to public comment. Do we have any speakers for public comment?
We have no public speakers at this time.
Okay, great. Thank you very much. Moving along to the manager's report. Mr. Holub.
Good evening, Chair, Vice Chair, Commissioners. Jonathan Holub, Rent Stabilization Housing Manager. First, looking at the look ahead, we have 1 appeal this evening. Next meeting on October 14th, there are 2 appeals scheduled. We will also be getting a report back from the Ad Hoc Committee on Valuation Guidelines. On the 28th, 2 more appeals. There'll be no meetings in November because both the regular meeting dates fall on holidays that month. I'll be back in December. I'm sure we'll be adding things to the agenda at that point. I know I've said it at every meeting, encourage tenants who are in arrears for COVID-19 related rent to apply to housingiskey.com. It's particularly important now, given the fact that the moratorium for non-payment of rent due to COVID-19 related reasons is set to expire at the end of this month. By applying to the program, while the application is pending, the tenant can create a defense to an unlawful detainer action while they wait for that application to be processed to see if they will get funding. So aside from the fact that obviously landlords want to be made whole and tenants want to get out of arrears, it's important for a tenant to do so to protect their tenancy. Along those same lines, the council on Monday directed staff to issue, or the city manager to issue an emergency order extending the county moratorium bases for prohibiting eviction if the county doesn't act. And the next County Board of Supervisors meeting is on September 28th. I suppose they might act at that time. I haven't seen an agenda for that meeting yet. But if they do not, as I said, council has directed the city manager under his authority to act as the director of emergency operations to issue an order extending those bases for the moratorium, which do not include non-payment for COVID-related reasons. It does include, however, no fault evictions. That's my report. If there are any questions, I'll be happy to take them.
Commissioners, questions? I see one. Commissioner Kirby.
Yes, could you explain how residents of West Hollywood would be affected then? If it doesn't include the non-payment of rent? I misunderstood that last part.
Sure. Well, currently, there's two components to the moratorium. There's the statewide moratorium, which covers non-payment of rent due to COVID-19 related reasons. That's what's been in effect for both by local and state law since the beginning of the pandemic. Starting on September 1st, 2020, the state law took effect with respect to that basis for eviction only. The state law puts limitations on a local jurisdiction's ability to extend that portion of the moratorium. The other portion of the moratorium has been covered by the county moratorium, and that relates to other reasons that would be a basis for eviction that are currently, under the moratorium, such as the main one being no fault evictions. There are also a couple others, but I think that's the main area that concerns most of the public at this time. If the county extends their moratorium by the end of the month, presumably if they did so, they do so at their meeting on the 28th, then that would cover tenancies in West Hollywood. What the city council directed on Monday was for an emergency order to issue from the city manager's office to extend the county reasons for the moratorium beyond the 30th if the county doesn't act.
And so does this include Ellis Act evictions?
Yes.
Thank you.
All right. Any further questions? I see none. Mr. Holub, thank you very much. All right, moving on, everyone. We are moving on to our appeal portion of the evening. It looks like we have one appeal tonight. This is on D-4581. Madam Secretary, do we have representatives for both
Mr.
the
Chair?
tenant and the... Yes, go ahead.
Sorry to interrupt. Before we begin, I will be recusing myself because I have a friendship with one of the parties in the case.
Okay, perfect. And before you recuse yourself, I skipped ahead on the agenda for commission comments. So I want to see if anyone has comments. All right, so I was clairvoyant and I knew there would be no comments. So we're moving on to the appeal. Commissioner Kirby, thank you for recusing yourself. All right. Madam Secretary, do we have a representative for the tenant and the landlord?
Yes, I'm admitting Brian Kunha and Mark Howell.
All right. Okay, it looks like we have both of the parties here, Mr. Howell and Mr. Kunha. Mr. Kunha, you are the tenant in this matter, and Mr. Howell. Secretary, do we have a representative for the tenant and the landlord? We have some feedback. Mr. Kunha, if you could go on, if both of the parties can go on mute for a moment, that would help us with our tech issues. Thank you.
Should I be seeing a video?
Did you call in or are you on the web?
I'm on the web. I'm on video on Zoom.
Okay, then you should. It's not necessary for you to see us, but yes, you should.
I see you guys. I just don't see myself. I don't know if
there's a button in the bottom of your Zoom that says start video. I don't. There you go. Okay, perfect. There you go. And if you can go on mute while I go through some instructions, that would be great. All right. So how this will work is we're going to hear a staff report from our legal counsel, and then the appellant, which is Mr. Howell from the landlord side, will go first. You're going to have a total of 5 minutes to speak tonight. You can break that 5 minutes up into any way you would like. 1 minute, 4 minutes, 4 minutes, 1 minute, however you'd like. And then in between your two sessions, Mr. Kunha is going to speak, and then your remaining time will be your rebuttal. Mr. Kunha, I don't know if I'm saying that right, but your 5 minute portion will be 5 minutes straight, no rebuttal. When you both come on, and I'll remind you of this, you're going to state your name, city of residence. Mr. Howell is going to tell us how he would like to divide his time, and then you will proceed with the comments. So again, we'll start with the staff report from legal counsel, and then we'll be back to the two of you. Thank you.
Good evening, Chair, Vice Chair, and Commissioners. My name is John Adelizio. I am the legal counsel to the Rent Stabilization Commission for the City of West Hollywood. This appeal was filed by the landlord, LaFontaine Development, LLC, in response to the hearing examiner's decision determining the maximum allowable rent. I'll just refer to that as the MAR. The tenant, Brian Kunha, resides at 1285 North Crescent Heights Boulevard, Unit E, and he executed a 6-month lease, which set the term of the tenancy from June 15th, 2020 until November 30th, 2020, and thereafter it became a month-to-month lease. The lease set the rent at $1,950. However, the lease included various concessions that lowered the monthly rent for the 6-month period to $1,550. After the 6-month period, the lease provided that the rent would return to the $1,950. Tenant filed an application seeking a MAR determination, and a decision was issued which determined that the MAR was $1,550. Landlord's appeal claims that the decision is clearly in error, is not reasonably supported by the findings made or evidence in the record, and is contrary to specific provisions of law. And specifically, landlord argues that the evidence shows that the amount that actually was demanded was $1,950, and that the hearing examiner incorrectly interpreted the RSO. Staff has reviewed the appeal record and recommends affirming the hearing examiner's decision. Staff believes that there's substantial evidence supporting the decision. For tenancies commencing after January 1st, 1996, the MAR shall be the initial rent established for the tenancy based upon the monthly amount actually demanded, received, or collected, plus any adjustments allowed under the RSO. Here, the evidence shows that the amount that was actually demanded and charged to the tenant during the entire term of the initial 6-month tenancy was $1,550. Landlord claims that the invoice ledger shows that the $1,950 is the amount that's actually demanded to the tenant. However, the ledgers that are submitted into the evidence show that the quote total that's charged and demanded from tenant is set at $1,550. Further, other provisions of this ledger, such as quote the amount received and quote the balance due, was all based upon this $1,550 amount and not the $1,950 amount. Therefore, staff believes that based upon the above, the commission should adopt resolution RSC 21-600. You as the commission have the power to affirm, reverse, modify, or remand the appeal decision of the hearing examiner. The commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the commission to make sure there is substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, then the decision must be upheld, even if there's also evidence that could support a different outcome. The commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. As it relates to questions of law, the commission applies an independent or de novo standard of review to the hearing examiner's conclusions of law. Thank you.
Commissioners, thank you for that. Any questions? I see none. All right. Thank you for the staff report. All right, moving on. All right, so we are going to start with Mr. Howell. You can turn on your mic. Thank you. You will state your name, your city of residence for the record, and then you will also tell us how you would like to split your time. And then once you've done that, you may proceed with your comments. The only rules, please keep on topic. No drama with the other parties, please. We try to keep it respectful here. And then only evidence that was presented prior, things that were raised at the hearing or evidence submitted to the hearing examiner may be discussed. So anything that's transpired since, et cetera, would be considered new evidence, and we cannot consider that. So don't waste your precious 5 minutes on that. So you may go ahead.
Hi, my name is Mark Howell, and I'm representing ownership and management. I think I would like to split my time in 4 minutes and 1 minute.
All right, you may proceed.
Okay, thanks so much. Everybody's busy, and I know you're managing crises bigger than this one. So I just want to say thank you to all of you for the opportunity to be heard. So per the RSO, the maximum allowable rent shall be the initial rental rate established for the tenancy based upon the monthly amount actually demanded, received, or collected, plus any adjustments, et cetera. That statute's written with 3 conditions that are disjunctive, not conjunctive, meaning the conditions are expressed as alternatives, A, comma, B, or C. They're not joined as a 3-pronged cumulative condition, A, B, and C, demanded, received, and collected. That's not how the statute is written. Landlord met the standard in the statute in our demand. So let's look at the word demand. The definition of demand is asked for with proper authority or claimed as a right. That is in its entirety the full and initial principle definition of demand in the dictionary. What was demanded, what was claimed as a right every month, including the first month, was $19.50. That evidence is in the lease. It's in the rent registration that was signed by the tenant, acknowledging it was $19.50. And most important, it was in the invoice that we sent every month to the tenant, including the first month. We made a demand. We claimed as a right $1,950 for each month. Then we proceeded to issue back credits to the tenant. So there can be no argument here. Everyone agreed that $19.50 was the rental amount. And by his own testimony in the hearing, Mr. Kunha made 3 key statements. He knew the apartment had rented previously for $2,200 and $2,400 per month, establishing the market rent was much higher than what we charged him. Second, he said that he'd agreed that the rent would be $19.50 when negotiating the lease, and he assumed it would come down because we were in a pandemic. And third, he testified that he took that lease agreement to the city and to legal counsel before signing it, was told that the rent would be set by the amount he pays the first month, so he went ahead and signed it, believing that it wouldn't be enforceable. So there is no question that both parties agreed that the rent was going to be $19.50 per month. So just practically, if we can just look at how we approach this, we could have said to Mr. Kunha, give us a check for $19.50. And then when it clears, we'll issue you back a check for $400 a week later. Now, that would have been a headache. That would have been difficult and would have actually put a higher financial burden on the tenant. Instead, we decided to streamline the process. So he didn't come out of pocket an extra $400 and we didn't have to go through the paperwork. It was mutually beneficial. The net effect's the same. That's a much more tenant-friendly approach to providing a limited time discount to the tenant as a move-in incentive and to still secure the fair market rent for the unit. So this is totally compliant with the rent control rules. If the tenant paid management $19.50 and we cut a check back for $400 a month, that's 100% compliant. But if we streamline it, save paper, save the headache, allow the tenant to deliver a lesser cash amount, lessening his financial burden, that doesn't pass muster. I have to challenge what the thinking behind that. So not only did the landlord demand 1950, we could have actually received 1950, collected 1950, actually satisfying all three prongs of the statute. But we're trying to be reasonable landlords in the middle of a pandemic in the interest of fair play and working together, easing the burden on the tenant. We did it this way, easier for everyone, better for the environment, less paper, less headache. This was an arm's length transaction. We all agreed this was a credit. The rental amount was 1950. That's fair market rent in this building, in this neighborhood. So we felt like we were doing him a favor. And we like Mr. Cunha. There is no drama, there's no bad blood here. But now you're penalizing us for streamlining the process, even though we met the burden, the standard in the statute. So just out of curiosity, what happens if a landlord gives a first month free incentive? Does that mean that the apartment is gratis as long as the tenant lives in that unit? They get it free because the amount actually collected, demanded, received, or collected that month was zero? The MAR should be established in 1950 per month.
Excuse me, Mr. Howell, you have 1 minute left.
In my total of 5? That was 4?
Yeah. That was 4.
Okay, I'm done. Thank you.
Thank you for that. We will move on to Mr. Cunha's 5 minutes, and then we'll go back to Mr. Howell for 1 minute after that. So Mr. Cunha, if you could state your name, your city of residence, you'll have 5 uninterrupted minutes to state your case. And same rules apply. Please be respectful, keep on topic, and only evidence that's been prior presented, nothing new. You may go ahead.
Thank you. My name is Brian Cunha. I live at 1285 North Crescent Heights, apartment E. I moved into the unit in June of last year. The pandemic was starting going on. I don't have a lot to say to this because we've already hashed this out before in a long hearing. I'm friendly with Mr. Howell and everyone in the building, so this is just kind of a business thing, and we both accept that. I believed that my rent would be continued on at the $15.50 at the end of the 6 months. That's true, and it was raised to $19.50. I did. There's only 2 things I want to correct. I didn't run it by the city before I moved in. I didn't run it by legal counsel. I ran it by a friend who gave me advice on it, who works in that industry. I didn't run it by any legal authority. Other than that, I stand by my previous testimony and believe that $15.50 should be the rent because that's what it was established at. I had mentioned before that it kind of feels like an open-ended lease, which they used to do on vehicles, where you would lease a car and you wouldn't know the end price, and then they give you this balloon payment. They knew when I moved in that I couldn't afford the $19.50. That's why I moved in at the $15.50, and I stated that when I moved in, that when they came back to me at the higher price, I said, I can't afford that. And they came back at $15.50. They said they had this lease the way it was written, which is interesting. And I said, I'd prefer to just have the lease straight up written. And I was told that that's how it needs to be written. So I signed it believing that at the end of the 6 months, it would continue at $15.50, that just for legal reasons, they had to write it that way. But I would not have moved into a place knowing that 6 months later, my rent would go up by $400, especially as everyone's incomes went down. So other than that, I had stated that previously in the hearing. So I'll give up the rest of my time. Thank you.
Thank you. Commissioners, do you have questions for Mr. Cunha? Yes, Mr. Topshin.
Yes, thank you, Chair Martz. A question to Mr. Cunha. So you mentioned that prior to signing the agreement, you consulted not with the rent division, not with the department, but you consulted or you spoke to a friend?
Yeah, I just had a friend, a client. I'm an IT consultant. I had a client who wanted to look it over. Looked it over. He's in that business, and he just said, looks good. Go ahead and sign it. He said that. So, go ahead.
This agreement, the one that we have on the record, you talk about that agreement, right? That states the moving rate. The initial rent established at $19.50. So the friend, is that friend a lawyer?
No, it's just someone who works in real estate and said that he didn't believe that anyone would increase the rent in 6 months because we were going down so much at that point.
Okay. But thank you. But the next question is, when you signed this rental agreement, so you realized and you understood that you're signing a legal document that sets the initial agreement, right? That's what the rent was, and you didn't have any questions about the 1950.
I did. I'd mentioned to, I was negotiating it with one of the representatives, Christopher, and I said, they started out at, I believe, 1950, and we kept going down on the price until it got to 1550. And I said, you know, that's the most I could do. And then they said, great. I think, you know, they consulted, they came back to me and said, fine. And then they sent me the lease, and I said, you know, the lease that goes up, and they said, this is just how it has to be written. So I was assuming that just for, I'm not a lawyer, so I don't know, or really in real estate myself, so it had to be written for some reason like that. And truly, I'd expressed to them that I would not have moved in had I known it would have gone up by $400, because that puts me in a really difficult position, as it would anybody.
What happened at the end of the lease? You went to the city, or what happened? So you were asked to pay $1950, and then you disputed it, or? Yeah, I reached out to Rin, who used to work with the company, and she said that I needed to sign the lease or move out, the new lease for $1950 in December, or I need to move out. And I said, well, are they going to negotiate with me? And she said, no, that's the price. And I was kind of shocked, because the neighborhood is emptying out at that point. Like, everything was for rent. There are many, like, I don't know, a lot of units in our building for rent. There's one still below me for rent for $1950. So I don't believe it's the market rate. And it's been for rent for, I don't know, 8 months or something. Okay, so you answered the question. So you basically, you said that you were told to sign a new lease with 1950 rent, or you have to move out. Okay, thank you, sir. You're welcome.
Commissioners, further questions for Mr. Kuna? I see none. Okay, great. We will return to Mr. Howell. On the landlord side, again, you have 1 minute for rebuttal, and then we will ask questions if we have any. You may go ahead.
Okay, this is going to be a speed through. As you know, the value of a multifamily property is based on the revenue stream. So an $850 in this unit decrease from $2,400 to $1,550 represents a staggering decrease in the value of the building that we never would have made on a permanent basis. That's why the lease was written, to allow Mr. Kunha a place to come into the city that was furnished for a short period of time. So the city charter talks about protecting tenants' rights, and that's fine. It's fair and reasonable. It's well and good, but it cannot extend to rewriting the rules of grammar or redefining words. I didn't say the examiner misinterpreted the RSO. That's a misquote. I said the hearing examiner and the staff have both chosen to not provide a just and fair rendering of the law. The examiner said this is a case of no good deed goes unpunished, so don't punish us. This board can fairly and appropriately establish the MAR in 1950. And we can choose to negotiate with Mr. Kunha, reduce the rent of the MAR to something that we can both live with, and allow us to do that, to meet him in the middle, which I've expressed my willingness and a commitment to do. We can't negotiate it up. If you set it at 1550, he and I can't get together and say, okay, this is where we're going to settle.
Excuse me, Mr. Howell, your minute is up.
Okay.
Thank you. Thank you. Commissioners, questions for Mr. Howell? Yes, I see Commissioner Topshin. You may go ahead.
Thank you, Chair. Mr. Howell, I have a question. So why did you require the tenant to sign a new, or the landlord, why the tenant was required to sign a new lease at the end of this one? Okay. And wouldn't that lease go month to month under the RSO? That is what the rule is. When the lease expires, it goes month to month. The tenant doesn't have to sign a new lease.
Well, my understanding of the RSO, and per our attorney, our counsel, the landlord has one window of opportunity to maintain a lease agreement with a tenant. When the initial lease agreement expires, the landlord has the right and the privilege of saying, we want to renew the lease. If the tenant says, I don't want to renew the lease, I want to go month to month, the landlord has the right to say, then we are going to take our right and say, you're going to have to move out. We are not required to go on a month-to-month lease with a tenant. We have the right, one time only, to say we want to extend the lease and sign a new lease commitment. And if the tenant doesn't want to, then we have the right to say we are terminating the lease. Now, if we miss that opportunity, then we never have it again, and it is from that point forward always a month-to-month lease. Okay. So we chose to exercise our right and say we want to lock you in, as we do with our other tenants in the building. We want to lock our tenants in.
Thank you. I'm not sure if I would agree, but again, I'd like to hear maybe the legal counsel commenting on that. If the landlords have that window to execute a new lease after the original lease expires. So maybe the legal counsel can explain it, but thank you very much. Thank you, Chair.
Yes, commissioners, any other questions? Vice Chair Copeland, go ahead.
Yes, I have a question. The original lease that Mr. Cunha signed was for 6 months.
Correct.
Is that your normal way of doing business, number one? And number two, the second lease that he said he was forced to sign, was that for 12 months or for 6?
Okay. With all due respect, he wasn't forced to sign it. We proffered it and asked if we want to sign the lease, and this whole thing went off the rails. So we never forced him. We never tried to execute any kind of an eviction. So with all due respect. At the time, it was legal to execute a lease of more than 31 days. That was the legal threshold for a lease agreement in the city of West Hollywood when we signed a 6-month with Mr. Cunha. So yes, we had a thriving business of, we have 10 different properties that we manage, and we had a thriving business of furnished flexible stay units, always within the legal limits of the city of Los Angeles, city of West Hollywood, always over 31 days. So when he signed that lease, we entered into that lease agreement with Mr. Cunha. He wanted a set period of time. We said, okay, well, 6 months. And we agreed on a 6-month lease. So when we proffered that second lease to him, again, our understanding from our attorney, Craig Mordo, who is professed to be an expert in this arena, it had to be the same terms. So even though the city at that point had required a 1 year as the minimum lease agreement, well, what do we honor? Do we honor the part of the law that says it has to be the same terms when you ask for a new lease to be signed? Or do we honor the part of the law that says a 1 year is a minimum, is the legal minimum? So we said, well, we should honor the terms of this lease because that's specific to this scenario. And we proffered a new 6-month lease.
Okay, thank you very much.
Commissioners, further questions? Yes, Mr. Maggio.
To the legal counsel, do we have to honor the 6-month or do we have to honor the year?
Is that for our legal counsel?
Yes.
All right, thanks.
I think for legal questions like that, let's wait until after all the questions are done and the public comment portion is closed, and then I can answer that in deliberation.
All right, I'll withdraw that.
Commissioners, any other questions for either the landlord or the tenant in this matter? All right, I see none. Mr. Howell, unfortunately, your time's up, so we can't take any more comments in your time. So we will enter deliberations now. If you could both go on mute, and we will deliberate. Commissioners, you may now deliberate.
Chair Marks,
yes.
Chair Marks, can we have the legal counsel back? Maybe we can ask
absolutely.
questions before we begin the deliberation.
Absolutely. That's
thank you.
Part. Yep. Commissioner Thompson, you can go ahead, and then Commissioner Maggio, and then whoever else after that.
Thank you, Chair. A couple of questions. The first, Mr. Natalizio, if you can explain what the owner said. I want to know if it's a true, correct information. When the lease is up, the landlord would have that window to offer a new lease, and if the tenant doesn't sign that a proposed new lease agreement, the owner may ask the tenant to vacate the unit. So my understanding was that is not the case, and after the lease expires, under the RSO rules, the tenancy automatically goes from month to month, and that is a protection that the RSO provides. Otherwise, if it's not true, so then the tenant shall remain in the unit and continue the tenancy under the same terms and conditions. Can you just please explain?
Sure. I think the section that the landlord is referencing, if everyone wants to look at it, is section 17.52.010. This is the chapter or the section regarding grounds for termination. And I believe what they're looking at is number 6, which is the refusal to renew lease. And in that section, it says the tenant of a dwelling unit who had a written lease or rental agreement which terminated on or after the effective date of this title, has refused after written request or demand by the landlord to execute a written extension or renewal thereof within the written period prescribed by the lease or state law for a further term of like duration with similar provisions and on such terms as are not inconsistent with or in violation of the provisions of this title. So essentially what that's saying is that if essentially if the lease allows it, then it can be done. So it's going to be determined by the lease language. So does that answer the question?
So if the lease says that at the end you will have to sign a lease, a new lease or extension to the lease, that would be okay. Otherwise, the tenant can be evicted or has to move, something like that.
Right. So if the lease was just for 6 months and they said at the 6 months this lease is terminating, then presumably under this section, if the landlord said, at this point, we're demanding that you execute a written extension or renewal, and they change, various terms, presumably, yes.
So the further term of like duration with similar provisions, if I am the tenant signing the proposed lease after the expiration of 6 months, so then the like duration would be another 6 months, not the 12-month period. And if in this particular case, if that proposed lease doesn't include the concession term, so I could say that this is not consistent with the original lease, then I don't have to sign and I cannot be evicted for it.
Well, so the key is you have to look at least for what the landlord is arguing for this section, you'd have to look at, it requires that it still be similar provisions. And so the issue with the 6 months and 12 months is not, I don't think, directly relevant to this appeal, just in the sense that at the time, 6 months was a time period permitted under the RSO. And I'm assuming presumably after the 6 months was up, the code has changed to require a 1 year. So I don't know if necessarily that is, I guess, germane to this specific appeal. So the fact that they were asking for a 1 year lease after the 6 months to be in compliance with the RSO, I mean, off the top of my head, I'm not seeing how that would be on its face invalid, or if they offered the 6 month again because they wanted to be, I guess, in compliance with this section. I guess I'm not too sure off the top of my head how we would rule on that in that kind of hypothetical situation. But I think for purposes of what the landlord is arguing, if we would have to look at this specific section and look to see the terms of the lease.
I see. And if I may ask you another question, is that I know this is not an easy case to me, because it all depends how we interpret the language of the ordinance. And I think the ruling also have to be consistent with the prior cases, similar cases that we had if we set precedent for this type of scenarios. Because if we read the actual language of the ordinance, the interpretation could be different. If we're saying that the rental agreement is the governing document for the tenancy, and if we read this section of the code that says under number 3, for tenancies created or after January 1st, 1996, the maximum allowable rent shall be the initial rental rate established for the tenancy. So the interpretation could be, I have the rental agreement, I negotiated the rent, it says there the initial rent is $19.50. So the understanding could be this is the rent, regardless of what was paid. But based on the report that we're reading, the interpretation by the examiner was different, right? It was based on the actual rent monies that were accepted and paid or collected the very first month, which was 1550. So now I'm kind of turned on this between these two philosophically different approaches under the same code. And I will definitely like to hear my other fellow commissioners what they have to say. But I guess my point will be, I always look at the rental agreement as a governing document, but the question would be, are there any cases, Mr. Natalizio, that we had recently in the past with a similar fact pattern that we could rely on and to see what was determined in those cases or the case, if there are any?
So I asked staff to review prior cases to see if there's any sort of precedent that the commission can follow. And at least in what staff was able to research into, there's been no case like this before the commission. There was a case that was appealed to the commission that involved a situation like this with rent concessions. It wasn't directly on point, but it at least involved rent concessions. But that case, that appeal was ultimately withdrawn before the commission heard it. So at least right now, our understanding is that this would essentially be some sort of case of first impression for this commission. And I do think that the interpretation is certainly challenging in the sense that you have essentially we're asking the commission to review the language of the ordinance and set forth the commission's understanding of specific language. As a staff report says, it's staff's understanding of the language that it can't just be what's ever in the lease, because if what's ever in the lease is $4,000 and then they only charge $1,000 for a year, and then after the year it raises back up to $4,000, they say that's what's in the lease. It effectively bypasses the controls in the RSO, right, to protect tenants. And so what I'm not trying to say right now is that in every situation, rent concessions or some sort of rent perks like this would be unlawful. So I want to make that clear. But in this unique situation, you have a 6-month lease that then goes month to month. And for the entire duration of the 6 months, a specific rent was charged to the tenant. And it's staff's belief that if you look, I understand landlord's position is there's the semantics and saying there's a disjunction. And yes, that's true. But I think if you look at, the three things the landlord pointed out, demanded, received, or collected, it's staff's position that whether it's demanded, received, collected, it's 1550 and not the 1950. And so I'll let the commission deliberate, but I hope that kind of gives you the background to answer your question.
Yes, thank you, Mr. Natalizio. That I don't have any questions at this time, Chair. I appreciate that. Thank you.
No problem. All right, Mr. Maggio, I believe you had questions.
I have no question at this time, but I'm willing to, I'm ready to deliberate. Is that what you would like?
Any other questions for legal counsel? No. Okay. Yep. Mr. Maggio, you can kick it off.
Well, we have two competing factors here. There's no doubt. We have the agreement, the lease agreement, and then we have our ordinance. The agreement is very clear that the landlord and the tenant agreed that the tenant shall deduct $50 off each month rent in satisfaction of interest paid on security deposits. Monthly lease price is reduced to $350 per month for the duration of this agreement term, and then price returns to the effective rent of $1,950 as of December 1, 2020, unless a new agreement is negotiated. Now, our ordinance of 17.44.040, which establishes the maximal allowable rent, is the initial rent that is paid on the first check, which would be $1,550. So do we respect this agreement between the tenant and the landlord, or do we follow through on what the ordinance is dictating to us in regard to maximal allowable rent, which was initially established by first payment? Thank you.
Other commissioners, comments? Don't be shy. Yes, Commissioner Ayers.
Yeah, Commissioner Maggio raises great points. And I know the person representing the landlord mentioned that, quoted the hearing examiner as stating no good deed goes unpunished. And so please don't punish the landlord. I think the hearing examiner made the right decision in coming to what the MAR is. Where I don't agree with the hearing examiner is I don't think this is a case of no good deed goes unpunished. I think this is a case of the property manager not taking into consideration what the municipal code states. And I think he made a mistake in executing this lease, the 6-month lease with this kind of language in it. Because if what he was intending to do was to raise the rent at a later time and make it consistent with code, he failed to do that because he didn't adhere to what the code states. So with that reasoning, I do support the hearing examiner's decision.
Thank you for that, fellow commissioners. All right, I will jump in. Commissioner Ayers makes a lot of the points that I was going to make. In contract law, you can put anything into a contract, but if it violates city, county, state, federal law, it's void. It's probably crude, but if you make a contract to engage in sex work, which is illegal, that contract's void, which I use when I'm in my lawyer job all the time to explain how contracts work. So we look at a contract, but we start with our municipal code as the kind of base rules that we're dealing with. And I think staff is correct in how they're interpreting this. I know the landlord has put a lot of emphasis on one word in our code, demanded, but received and collected are equally weighted in our code. And staff made a good point that the code includes the word actually demanded, and had they wanted it to just say demanded, which could have been interpreted as the 1950, they wouldn't have included the word actually in there. And so we look not just at the lease, but we look at the actual conduct of the parties here. And the ledger includes a discount every month, which staff has persuasively argued, in my opinion, that shows that the base rent, the MAR, is the lower of the two rents in dispute here. So I think that there's evidence in the record to support this decision. I think the legal basis is sound upon which staff has written the staff report. So I would uphold the hearing examiner's decision in this matter. And I would just say to the parties, I appreciate that this is a business dispute and there's not, anger and hate, because we do see that here. I do think it is a important lesson, which we've said to other parties in other cases, that you have to be really careful how you draft contracts, how you interpret the city municipal code, because it is strict and it's written to protect all parties, but it's written hopefully for clarity. And in this situation, maybe there wasn't that clarity, but that's the intent of our municipal code, is that there are rules that have to be followed. And unfortunately, sometimes they aren't. One side may feel hurt or that we're not doing it correctly, but I think in this situation, staff is correct in their interpretation. So I'll entertain other comments. Vice Chair Copeland.
Yes, I agree with Chair Marks that any part of a contract or a lease that's in direct contravention of the law is not enforceable. And as a rent regulated city, we have an ordinance that governs what the maximum rent increases can be. An ordinance against excessive late fees, which I happen to notice $50 per day in the fine print in this one. Causes for eviction, things like that are regulated by the ordinance in a city like ours. And there was no vacancy that occurred to allow vacancy decontrol. So the initial month that was paid was $1,550. I think I know it seems like a sticky point, but in the end, we have to go with the ordinance, which is the law here that governs these things. And I think the interpretation of the hearing examiner was correct. So I would be in favor of affirming as well. Thank you.
Thank you for that. Commissioner Montemuro.
Thank you. I don't want to belabor the point. Ultimately, I agree with, I think, all the comments that were made by my colleagues. I think what I'll just add is I think this is an important case, especially given that legal counsel said there's not precedent on this yet. I think it's important that we look at the municipal code and the ordinance and ensure that we're applying it here carefully and thoughtfully. I think if we affirm the decision, which I'm prepared to do, we will be doing so. And I think this is important because I think there's probably many other situations that we may see similar to this due to the pandemic. And I think ultimately, while the intentions may have been different for the parties, the contract, the way it's written and the way that our municipal code is written is very clear. And I'm prepared to affirm the hearing examiner's decision.
Thank you for that. Commissioner Topshin.
Thank you, Chair. Yes, this was not an easy one for me, but what I'm hearing is, and I appreciate that the legal counsel explained a lot of things that I had a trouble of, seeing it differently maybe. And I agree with you, Chair Martz, that any agreement, any contract that is in violation of the law shall be void, and that I think we even have a provision in the RSO that states that. So again, if we go back to what was the intent and the way that the legal counsel explained to me, explained to the commission, I think that was the intent of this provision, to consider what was initially collected and accepted or received, whatever the language is of the code. If that's the intent of that particular provision, and if that was the understanding of the examiner, then based on what the legal counsel provided the information, I would say that I'm going to affirm the decision of the examiner. Thank you.
Thank you. I would entertain a motion if we have no further comments. Yes, Commissioner Ayers.
I move that the commission affirm the hearing examiner's decision as to application number D4581.
Second.
We have a motion. We have a second. Madam Secretary.
Sorry,
roll
Chair
call,
Mark.
please. Yes, go ahead.
Sorry, I just want to make sure that Commissioner Ayers, her motion is also intending to include adopting resolution RSC 21-600.
Yes, amend it to include resolution RSC number 21600, please.
Thank you for that. Mr. Maggio, does your second go along with that?
Yes, with that amendment, I will continue to second the motion.
Wonderful. Thank you, Madam Secretary. If we could have a roll call vote, please.
Commissioner Ayer,
Yes.
Commissioner Kirkpatrick is recused. Commissioner Maggio,
Yes.
Commissioner Montemayor,
Aye.
Commissioner Topchian,
Aye.
Vice Chair Copeland,
Aye.
and Chair Martz.
Aye. Thank you for the roll call vote. The motion passes unanimously. The parties will be moved back into the waiting room. You're welcome to watch the rest of the meeting if you would like. If you have questions, you can reach out to the Rent Stabilization Commission, 323-848-6450 or rsh@weho.org. Thank you both. All right. We will move on our agenda to new unfinished business. Mr. Holub, do we have any? And Commissioner Kirkpatrick, welcome back.
No, there's no other business tonight.
All right, thank you for that. Do we have any items from staff?
I'm just gonna really drive this home. Again, to tenants, please visit housingIsKey.com to access the COVID rent relief program. If anyone out there has questions about the expiration of part of the moratorium, as I discussed earlier, what extensions are going to be coming, please call the division at 323-848-6450. Also, we can be reached via the website at rsh@weho.org. Thank you.
Thank you, Mr. Holub. Moving on, do we have any public comments that have come in since our last question on that?
We have no public questions, no
All
public
right.
comments.
Thank you for that. Commissioners, any comments? Yes, Mr. Topchian, Commissioner Topchian, sorry.
Thank you, Chair. I just wanted to, while it's still fresh in our heads about this case, I just wanted to mention something. I think this was a very interesting case, and we kind of, with our decision tonight, we set a precedent for other cases. So as I said, I had my doubts, but I appreciate the comments made by the commissioners, and of course, Chair Martz, your explanation was very helpful, and of course, the legal counsel explanation on the matter. But I think maybe the staff can look into this section, this particular clause or section of that code, to see if we can somehow change it, tweak it, the language, so this issue will not have to come back before us again, because rent concessions are good things. And by a decision tonight that we may actually this decision basically may tell the landlords, hey, don't give any rent concessions in the future because you may have problems. And that's what is going to discourage, this decision tonight may discourage the landlords to do so. And I didn't want to see that, because in the post-COVID world, there could be more of this rent concession tenancies. Then the rent may be negotiated $2,000, but then, hey, just to move in, you for next year or 3 months or 5 months, you can pay less, and that attracts the tenant. And I think that's a good thing to have a concession. So now, since I had, a lot of trouble, when I was preparing, I think maybe we can change the language a little bit, and maybe staff can look into this. And that would I propose, Chair Marks, if you can, if you have any power to suggest some sort of maybe a review or discussion by staff and the legal minds to see if there is something can be changed and that comes back to us that would exclude that would kind of state that the whatever is the rental agreement assigned, it's not the case. I don't know what would be the legal language, but do you understand what I'm saying? So basically just to fix it so they wouldn't have any issues in the future. That's my comment tonight. Thank you.
Thank you. Further comments? Commissioner Kupis.
It's more of a question for staff, Director Holub, regarding the upcoming, well, I guess that's not necessarily the upcoming eviction moratorium lift for West Hollywood, but regardless, if a tenant receives an eviction notice, we currently now the city provides legal services attorneys, right, for those who qualify, if not everybody, at least those who qualify. How do they access those services? And then also, how does the city monitor evictions throughout the city? Is there any way to do that? And could we maybe get not necessarily at both meetings each month, but maybe once a meeting a month, get an update on what the city is seeing, considering we're coming out of the pandemic and there's going to be a lot of confusion with both on landlords and tenants sides of understanding what evictions can occur. Thank you.
Sure. Regarding the most important thing I think you mentioned, which I should have, is that tenants in West Hollywood can receive full legal representation from BetSatic Legal Services. And that information is on the rent stabilization website. Actually, if you go to the website WehoTV.org and then click on the coronavirus banner and go to renter resources, the contact information both for BetSatic Legal Services is there. I also recommend that tenants who may be facing a rent difficulty at the beginning of October could also contact the Coalition for Economic Survival, which is conducting 2 clinics an evening, and it now has a portion of their program devoted specifically to West Hollywood tenants. That information is on the website. With respect to eviction tracking, I think you're right that obviously when the moratoria change, we're going to see possibly most likely not an increase. And technically under the code, we should be getting that information every time an eviction notice is served, or certainly when a summons and complaint are served. That needs to be filed with the division. That's a requirement of the code. So that's one way that we know the volume of evictions in the city. We can also ask BetSatic what kind of volume they're seeing. So I'd be happy to come back with that information on a monthly basis. I think perhaps starting in December. I don't think we'll have any clear indication at the October meetings. Maybe October 28th would be a good place to start, actually, because that'll be almost a full month since the rent provision goes away. And so I can see what we get filed in the office, and I can check with BetSatic to see what their volume is, and I can report that back to the commission.
One more question, Chair, if that's all right.
Yes.
Would it be possible at some point, whether it be October, December, whatever, and maybe their workload might be too high at that time, I don't know, but would it be possible to get a presentation on the eviction process, not necessarily what the rules are leading up to the eviction, but many tenants have no idea how the eviction process works. And I realized recently our office did a webinar on the housing is key, and we invited Beth Zedek to come and do a portion on just, and it was her idea. I hadn't thought of it, but she did a portion just on how the eviction process works and how it's supposed to function. And it was amazing. I've been on this commission for off and on for 10, 12 years, and I didn't understand the process and found it very interesting. And I think that not only us, maybe not Chair March, I think he deals with this a lot, but the rest of us, I think, would find it very useful along with our residents, just so people can understand what it's supposed to look like and some familiarity with it should they ever find themselves in that situation.
I'll check with Beth Zedek on that. I think that would be the appropriate. You said that they had done it at your office, and I think that they would be the appropriate organization to present that. Obviously, like we were just talking about, I anticipate their workload will increase. I know they're working really hard as it is, but if they have something prepared already, perhaps if they can bring to the commission, I will certainly talk to them about that.
Another organization that may be good for that is the Coalition for Economic Survival. And they are planning to hold a West Hollywood tenants rights town hall. Let's see, when is that? They just posted it on their Facebook page 2 hours ago. So they're already planning something that might answer a lot of community questions from renters.
That will be a Zoom. That's going to be a Zoom meeting, and I know many seniors do not have access to computers, so that's going to be a tough one. But it's available if they can get help to get there via computer.
They also do one-on-one counseling.
At Plummer Park, I believe you have.
Yeah, well, they used to have it in person at Plummer Park. I don't know at this time. I don't think Plummer Park Community Center is open at this time. So I think they conduct the one-on-one through phone calls, but that's definitely another option for seniors who don't have the capacity for a Zoom meeting.
Thank you for that. Commissioners, any other comments for this evening? I see Commissioner Montemayor wants to give a speech now. No, all right. Seeing no other further comments, this will move us to the end of the meeting. This meeting is adjourned to the next regularly scheduled meeting of the Rent Stabilization Commission to be held on Thursday, October 14th via teleconference. Thank you all. Have a good night.
Good night, everyone.
Thank you. Good night.
I feel like I worked so hard tonight.
You did.
Bye.